Good morning, everyone. So, moving on to Unit 4, which is distribution of legislative power between the Union and the states. This is lecture 1. We also have other topics included into it, which we will be doing in further lecture. In this one, we are starting with the basic of distribution of the legislative power between Union and the state. So here, distribution of power between state and central, it is a federal feature of the Constitution. The Indian Constitution, it have a unitary feature and it behaves as unitary at time of emergency. Normally, it is a federal constitution. Now, what does this mean? As we all know, our Indian Constitution, it is a federal constitution. Indian Constitution is based on the principle of federalism, and it have two scheme-fold distribution of legislative power. The first one is with respect to territory, and the other one is with respect to subject matter. And the constitutional provisions which deals with the distribution of power between the state and center is from Article 245 to 254. Article 245 talks about the distribution of legislative power between union and state with respect to territory. Before going on to the Article 245, we have to explain, in the case of state of West Bengal versus Union of India, what does the Supreme Court said? It said that Indian Constitution is basically federal, though in this case the Supreme Court held the Indian Constitution not truly federal, but in later S.R. Bomai versus Union of India, in this case Supreme Court clearly said that Indian Constitution is a federal constitution. And further now moving, that what does part 11 of Constitution deals? It deals with the three head under which the power of state and center are divided. That is the legislative, administrative and financial relation. So first we understood that our Indian Constitution is federal in nature, right? Now, moving on to the legislative distribution of power. The main characteristic of this federal constitution is the distribution of power between the union and state. An Indian Constitution, it provides for a new kind of federalism to meet its need. Now, in particular, in the matter of this distribution of power, our framers had followed the pattern of Government of India Act 1935. Right? Now, the 7th schedule of the Constitution, it contains 3 lists: the Union list, the state list and concurrent list. Right? However, if there is any conflict between a central law and a state law on a subject in concurrent list, then union law should prevail. We'll be explaining about it in later. So till now we have understood that distribution of power is an essential feature of federalism. And the object for which a federal state is formed, it involves a division of authority between central government and separate state. So our constitution makers, they have followed the Canadian scheme, which is that they have opted for stronger center. And so the Government of India Act 1935, it introduced a threefold distribution, that is federal, provincial and concurrent. Now moving on to according to Article 1st of the Constitution, India is a union of states, which means a federation of states. And there is in a federation a division of functions between the center and the state. So under Article 1, it is said that India is a union of states. And what does it mean? It means that a federation of states. And in a federation, there is a division of function between the center and the states. There is a division of the functions between center and state. And under our constitution, there is twofold distribution of legislative power. How they have distributed the legislative power. Now first is with the respect to the territory, and second is with respect to subject matter. Now with respect to the subject matter, our constitution has adopted threefold distribution, which are placed in the three list: union, state and concurrent list, right? The constitution provisions are given under Article 245 to 254, and the very important one is given under 245 to 256. Both of them are very important. And from the point of view of subject matter of legislation, 246 is important, so which we will deal. Now let us first understand with respect to territory, how there is distribution of this legislative power with respect to territory. Now legislative power of this parliament and state legislature, you have to understand this, that legislative power of parliament and the state legislature, they are subject to the provision of the constitution, which are like the schemes of distribution of power, then fundamental rights and other provisions of constitution. And Article 245 talks about distribution of legislative power between union and state with respect to territory. Exactly what 245 clause 1 says. It provides that subject to the provision of the constitution, Parliament may make laws for the whole or any part of territory of India. And according to clause 2 of Article 245, a law made by Parliament shall not be deemed to be invalid on the ground that it has extraterritorial operation, which means that takes effect outside the territory of India. Extraterritorial operation means that is takes effect outside the territory of India. Now this will be clear with the theory of territorial nexus. Now according to this doctrine, the legislature of a state may make laws for either whole or any part of the state. Right? For the state. It is talking about the legislature of state. Now what does this mean? This means that state laws will be void if it has extraterritorial operation. That is, if it is applied to subject or object located outside the territory of the state. If there is any subject or any object which is located outside the territory of the state and the state makes a law for it, then that law, it shall be void. This is what theory of territorial nexus is, and this is what Article 245 says. But there is one exception of this general rule. a state law of extraterritorial operation will be valid if there is sufficient nexus between the object and the state. And so this is done by the application of doctrine of territorial nexus. This is what doctrine of territorial nexus is. Now what does it says? That legislature of state can make law for either whole or any part of the state. So what does this mean? If it is making any law for which has extraterritorial operation, it would be void. But there is one exception to this general rule, that even if the law, state law of extraterritorial operation, if the state makes any law which have extraterritorial operation, it will be valid if there is some sufficient nexus, there is sufficient connection between the object and the state. And so this can be done by doctrine of territorial nexus. That is what nexus, there should be some connection, territorial connection, a nexus. Now moving on to the case. Name of the case is alright, so it is not given here, but I'll tell you the case. In this case, what happened? In the case of Wallace versus Income Tax Commissioner, Bombay. It's a much old case. So what does this doctrine was first evolved by the Privy Council in Wallace versus Income Tax Commissioner, Bombay. Now what happened in the case? Maybe pointer, pen. Wallace versus Income Tax Commissioner, right? So this is the case. WAAACE, this is E, versus Income Tax Commissioner, Bombay. Now what happened in this case will be understanding. A company was registered in England and was a partner in the firm. The facts are written over here that a company was registered in the England and was a partner in the firm in India. So it was registered in England, it was partner in the firm in India. Now income tax authorities sought to tax the entire income made by the company. So what did Indian Income Tax Authority sought? They sought to tax the entire company. Firstly, it was registered in England but was a partner in firm in India, and they sought to tax the whole company. Now what did the Privy Council said? That it applied the doctrine of territorial nexus and held. What did the Privy Council held? That levy of tax valid. It said levying the tax to the company is valid. So it said that derivation from British India of major part of its income for a year gave to a company for that year sufficient territorial connection. Now here again talking about territorial connection. The Privy Council found the territorial nexus between the company which was registered in England and was partner in firm in India. It found a territorial connection which justified its being treated as at home in India for all purpose of tax on its income for that year from whatever source income may be derived. Now what does this doctrine explain? That it is not necessary that the object to which the law is applied, it should be physically located, right, within the boundaries of the state making law. No, the object need not be physically located. It is enough if there is sufficient territorial nexus between the object and state making law. That is what it happened. There was a sufficient nexus. It has a sufficient nexus and it was registered in England, was also a partner in firm in India. Now, moving on to get back to it. Okay, moving on to the other case. So this is clear. Territorial theory of this territorial nexus and how was it applied in Palace versus Income Tax Commissioner case. Then Supreme Court applied this doctrine in state of Bombay versus RMDC. Case is given in this. Now what does happen in this case? Bombay state levied a tax on lotteries and prize competition. The tax was extended to a newspaper printed and published in Bangalore but had wide circulation in Bombay. So respondent conducted the prize competition through this paper. And court held that there existed a sufficient territorial nexus to enable the Bombay state to tax the newspaper. So again there was the court found the territorial nexus to enable Bombay state to tax the newspaper. As the tax, it was extended to newspaper printed and published in Bangalore, but it had a wide circulation in Bombay. And the respondent, he conducted the prize competition through this paper. So therefore the court said that it held that there existed a sufficient territorial nexus which made Bombay state to tax the newspaper. Right? Then again there was a sufficient nexus between persons sought to be charged and the state seeking to tax him. The taxing statute would be upheld. Now in this case the court also held for the application of this doctrine of territorial nexus there must be connection between for the application of doctrine there must be a connection between the state and the subject matter of law, which has to be real and not illusionary, right? It should not be illusionary. The subject matter of law, state, there has to be a connection. Then the liability sought to be imposed must be pertinent to that connection. And then whether there is sufficient connection is a question of fact and will be determined by a court. Again, obviously this has to be determined in the court according to the case to case and according to it is a matter of fact, a question of fact, that whether there is a sufficient connection, where there is a nexus, it has to be determined by the court. Then parliamentary law having extraterritorial operation. These four things should be seen for the application of this doctrine. And Union Parliament may make laws having extraterritorial operation, and such a law would not be void on the ground of having extraterritorial operation. Right? This is what is said in 245. Moving on to another case in A.H. Wadia versus Income Tax Commissioner Bombay. What happened in this case? Again the facts are written. Gwalior government had loaned at Gwalior large sum of money. They have loaned at a Gwalior large sum of money to a company in British India. Fine, clear. On the mortgage of debenture over property in British India. So they have loaned at Gwalior. They have loaned the money to a company in British India on mortgage of debenture over the property in British India. So now the interest on loan was payable at Gwalior. It was taxed under the Indian Income Tax Act. Now upholding the levy, Supreme Court said, what did the Supreme Court say? This, that in case of sovereign legislature, Question of extraterritorial of an enactment can never be raised. In case of sovereign legislature, it cannot be raised in the municipal court as a ground for challenging its validity. The legislation may offend the rule of international law, may not be recognized by foreign court, or there may be practical difficulty in enforcing them, but these are questions of policy with which domestic tribunal are concerned. So that was a till theory of territorial nexus. There were 1, 2 and 3 major cases which we have dealt with. This is Wallace versus income tax. Moving on to legislative relation. Now, distribution of this legislative power with the respect to subject matter. When we are done with the territory, with the subject to territory, here comes with subject matter. Now, in terms of 246, Article 246, there is threefold distribution of legislative power between union and state. It is given in 7th schedule of the constitution, which contains 3 lists. First is here written union list, right? It contains 97 subject and is the largest of all the 3 lists. Now, subject included in it affect the whole country. Absolutely. Now, let us understand what is it. What is it? Basically, union-state relation. Moving on to the first union list. It gives the exclusive legislative power to union to legislate on 97 items, which includes defense, armed forces. That means that the union list gives the union power to exclusively legislate over these 97 items, subjects which are given under the 7th schedule of the constitution. Now, what are these subjects on which union can make law? They are defense, armed forces. A union can make law on defense, armed forces, arms and ammunition, atomic energy, foreign affair, war and peace, citizenship, extradition, railway, shipping, navigation, airway, and so on. UPSC, income tax, custom duties, so many of things are there. Then union-state relation in legislative domain have been dealt in this. All right, we know the articles. The constitution evidently provides that parliament shall have special authority to make law for the whole or any part of terrain of India. Perfect. Now, this list contains topics like defense, foreign affair, currency, union duty, communication. This is what union list contains. Now, on the other hand, state list. Moving on to state list, it gives exclusive legislative power to the states. In the union, it gives the power to the union, the parliament to legislate on the items, subjects, and it gives under state list, it gives the power to the state, exclusive power over the 66 items. Now, what are these? They are subjects, supposedly they are a subject of local interest, such as maintaining law and order, police force, healthcare, right, sanitization, agriculture, transport, land policy, electricity in state, or village administration, etc. So the state legislature has the exclusive power to make laws on these subjects. Perfect. Moving on to concurrent list. It empowers both the union and state to legislate on the 47 item. So concurrent list empowers both, even the parliament, the union and the state. They both can legislate on the given subject, the given items. Both of them have right. In union, only the parliament can make laws. Then in state, only the state have the exclusive power. In concurrent list, both have. Now, what are the subjects in this list? That the national government and the state both are they are empowered to make the laws. Now, supposedly, for example, it is marriage and divorce. It is not written, I guess. it is written? No. Fine. I'll tell you the subject matters are marriage and divorce, transfer of property other than the agricultural land, education, contract, bankruptcy, insolvency, trustees and trust, civil procedure, contempt of court, drugs and poison, economic and social planning, trade union, newspaper, so etc. Many things. What is important is that both the union and state government are competent to legislate on this subject in concurrent list. And if there is a conflict between central law and state law in this subject, the subject in this list, then normally union law should prevail, which I'll be telling you later. Now, the power to legislate on any matter which is not given under either in union, in state or concurrent list, it is vested in Union Parliament by Article 248, and this is called the residuary power. Belongs to the Union government. So the residuary power, it belongs to the Union government. Perfect. Article 248 vests the residuary power in Parliament. Now, alright, we are almost done with this concurrent list. Under this rule, if there is any discrepancy, this is done. As an exception, if state law has been reserved for the consideration of President has received his assent, then the state law will prevail in that state. Fine, that is an exception, but the Parliament remain competent to override such law if there is any inconsistency. Then union government has an upper hand. Yes, if the law of union government and the state government, they clash with each other, former, that is the union government will succeed. But a state law on simultaneous list shall prevail over the central law. Yes, if the same has been reserved for the consideration of the President and his consent has been given, but this does not mean the central can't. Then constitution vests the residuary power with the central government, which I have told residuary power is that if there is any, the power, this is a power given to the union government, which is the power to legislate on any matter which is not given under the, not enumerated in the three list, union, state and concurrent. Then it is given to the Union Parliament by Article 248. So it says that Parliament has exclusive power to make any law with respect to any matter not enumerated in the concurrent list or state list. Yeah, of course, union list they can make. So any matter which is not given under the concurrent and state. Entry 97 in the union list also lays down that Parliament has exclusive power to make laws with respect to any matter which is not mentioned in state list or concurrent. Right. So this reflects that there is a leaning of our Indian constitution makers towards a strong center, giving this residuary power to the union government. It clearly shows leaning the constitution maker towards a strong center. Then it is established that in this distribution of power, union government has positively been given a preferred treatment. Perfect. Then union government can legislate on any subject included in the state list under some specific circumstances. That this is another thing, that union government can legislate on any subject included in the state list and under some specific circumstance. What are these? Supposedly, like 248 says, if the Council of State, that is Rajya Sabha, declare that it is necessary for center to legislate upon a subject in state list. If the Council of State says so. So in the national interest, it does. National interest is important over here. If the Rajya Sabha declares that it is necessary for center, then this resolution has to be passed by the majority of 2/3 of members present and voting. This is given under Article 249, and this resolution remains in force for a year, and it can be renewed by any number of times, but not more than a year. So second is when two or more states legislature passes a resolution requesting parliament, when two or more state legislature they pass a resolution and they request the parliament to legislate upon subject given in their list, in the state list. This is given under 252. Then the law passed by union parliament shall be applicable only to the states which demanded such legislation. So any other state may later adopt it by passing a resolution to that effect. Then for the enforcement of international treaties and agreement, so in the second point, there has been laws which are made using this provision of 252. There's like Wildlife Protection Act 1972, then Urban Land Sealing and Regulation Act. This was made by using 252. Then for the enforcement of international treaty and agreement, this provision enables the central government to fulfill its international obligation given under Article 253. Like Lokpal and Lokayuk Bill 2011, it was introduced in Parliament through the provision of this particular article. Then during national emergency, Parliament can legislate upon any subject in the state list. Absolutely. And this is given under 352. But however, even state can also legislate upon the same subject, but if there is any inconsistency, then central law will prevail. Then during president rule, Parliament can make laws with respect to any subject in the state list. The last point, in relation to the state, such a law continues to be operative even after the president rule, but it can be repealed, it can be changed, enacted later by the state legislature. So thank you, that's it, and we have done with the residuary power. We have done a lot in this. We have understood about that if there is any inconsistency, all I can sum up is that if there is any inconsistency, then central will be prevailing, central law will be prevailing, and how our Indian Constitution has given it more power. What is repugnancy, Article 254, we'll be doing this in another lecture though. But then you understanding the three list, union, state and center, the legislative relation, and the subject matter subject to the distribution of power, subject to the territory and in respect to territory and the subject. So that's it, and we have done with the cases. In the next lecture, we'll be doing further about doctrine of pith and substance, culpable legislations. Yes, thank you.